Shapiro from RPAG over to give a little regulatory update and insights for your plan-sponsored clients. Joel?
Hello, everyone. Sorry about that. That is part and parcel with what Jesse was just describing, and that's working from home and having yourself on mute accidentally. Happy to be joining you today. Wish it was under different circumstances, but with that, I am going to talk about a number of topics. I'm going to lead off today talking about the CARES Act. So if we can move to the next slide. On March 27th, the Coronavirus Aid, Relief, and Economic Security Act was signed into law, and a portion of that was directed specifically towards retirement plans, with the primary goals being loosening access to dollars in the plan for individuals, as well as providing some relief for plan sponsors. So we're going to go through each of the bullets here, and I'm going to give you a little bit of insight into what the Act contains. So first of all, they're allowing a $100,000 withdrawal, or up to $100,000 withdrawal. And they're calling this a coronavirus-related distribution. So if you start seeing the acronym CRD, that's what it's referring to. Essentially, what the Act does is it waives the 10% penalty on early withdrawals for amounts up to $100,000 from either a retirement plan or an IRA. That's taken between January 1st of this year and December 31st of this year. So the interesting element there is that it can be retroactive. In other words, distributions that were made prior to the enactment of the Act can fall within this concept. And the reason that that's important is there are tax and potential repayment elements that are attached to a CRD. But interestingly enough, we'll have to kind of wait to see how some of this plays out because of the fact that there are some unanswered questions. For instance, we're going to get to self-certification in a second, but how do you rely on self-certification for a distribution that was already taken? And wouldn't a 1099 be coded incorrectly? So take what I say today with a small grain of salt, because I'm going to be reporting primarily on what the Act provides, but we're going to need to rely on the IRS and the Department of Labor for a lot of backside guidance in regards to what the outcomes might be of some of these actions. So getting back to the CRD, the $100,000 withdrawal. So that's discretionary. So plans can decide if they want to add it or not. They don't have to add it. The CARES Act does not say that you have to add it. It also doesn't say that you have to add it all the way up to $100,000. So you can limit the amount that you want to make available in a CRD if your clients want to do that. In addition, this is only available to quote unquote qualified individuals. And a qualified individual is essentially an individual that's either diagnosed with COVID-19, whose spouse or beneficiary is diagnosed with COVID-19, or who experiences adverse financial consequences due to furlough, quarantine, layoff, reduction in hours, and inability to work due to lack of childcare due to COVID-19, or the closing of a business or a reduction of hours by an individual due to COVID-19, or, and here's the catch-all, factors determined by the Secretary of Treasury. So that can still be expanded upon. So those are the individuals that are going to be allowed to take the $100,000, up to $100,000 withdrawal through the 2020 year. In addition, these individuals will be allowed to pay the tax on the withdrawal ratably over a 3-year period. So they don't take that full tax hit in the current year. And in addition, and this is where it differs from a hardship withdrawal, individuals are going to be allowed to repay the withdrawal back to the plan from which they took it, and they can do so tax-free, and they can do that over a 3-year period without being limited by any of the plan limits under the Internal Revenue Code. In addition, they can repay that back to another qualified plan or to an IRA if they accept rollover distributions. So the Act provides quite a bit of flexibility. In addition, the Act also loosened access to money via plan loans. So if you remember, currently, if your plan offers participant loans, the maximum that an individual can borrow typically under the Internal Revenue Code is the lesser of $50,000 or 50% of their vested account balance. The Act increases that and essentially doubles it and says that if the plan so desires, they can allow participant loans up to the lesser of $100,000 or 100% of their vested account balance. Now, for these increased plan limits, again, it's limited to individuals that are qualified individuals. So those individuals that I rattled off before that are impacted by COVID-19. In addition to that, they're also adding some relief for participants that had an outstanding loan at present. So the thinking being that some participants, as a result of layoffs or furloughs or reductions in the compensation that they're earning, might have had potential issues meeting their repayment obligations under the current amortization schedules that they had with their plan. As a reminder, your clients, if they have a participant that stops making repayments, that can end up with a defaulted loan. A defaulted loan ends up being a deemed distribution, and a deemed distribution ends up becoming an unexpected taxable event to the participant. So they didn't want this unintended consequence that was going to evolve from what we're seeing from the pandemic to pile on to that participant who is already probably hurting from not having compensation coming in. So what they've allowed is, if the plan again allows, so the plan doesn't have to do this, but they can do it if they so desire, they provide existing outstanding loans with a repayment due date that can extend for a full year. So in other words, participants can elect to suspend their repayments for a full year, which helps them avoid that deemed distribution and then the taxable event. In addition to that, the suspension of the repayment also allows for an extension of the amortization period. So for instance, if the participant had a 5-year period in which to repay this, it ends up tacking on another year equal to the length of the suspension of the repayment, so that when they do come back from that suspension and they do start making their repayments again, they're not at higher levels because they essentially missed out on making repayments for a full year. So that's terrific relief for participants that are already in a financial hard place, to alleviate any potential tax burden on them. So that's the two loan provisions, and that's also the CRD. In addition to that, the CARES Act waived required minimum distributions for 2020. Now, that includes required minimum distributions that are attributable to 2019, but which weren't paid by January 1st of 2020. It doesn't include RMD distributions that were made in 2019. So this doesn't stretch back that far. It's just for required minimum distributions that occurred from the beginning of 2020 all the way through the end of 2020. And that means that for required minimum distributions that were made prior to the enactment of the Act, the participant is allowed to defer taxes and roll it back to the plan from which it was made, or to another qualified plan, or to an IRA which accepts rollovers. And we're going to need to see what guidance we get from the IRS in regards to the timing, because normally a rollover has to be made within a 60-day period. But as we can tell, the enactment was made at the end of March, and it's possible that a required minimum distribution was made at the beginning of January, which would potentially put us outside of that 60-day window. However, I suspect that based on the Act, that we will see the IRS come out with guidance that extends that 60-day period for the rollover. In addition, when we're taking a look at defined benefits and money purchase pension plans, the Act provides the plan sponsor with some relief. And the relief comes in the form of allowing these plans to delay any contributions that are due in the calendar year 2020 to January 1st of 2021. And that includes all quarterly contributions. Now, understand what I said there. It's allowing them to delay them until January 1st, 2021. It's not providing for a delay of a certain amount of time. So for each of the quarterly contributions that a plan might be required to make, it's not that they're all moved back an equal amount of time, but rather they're all moved back and aggregated to be due on January 1st, 2021. Plan sponsors are also going to have to remember that leveraging the delayed due date is going to subject the employer to interest on the delayed contributions from the original due date, and they should expect that leveraging the delay should lead to higher contributions in 2021. So, that's important for them to be aware. They can leverage this for some relief, but, the tax does come due essentially, and the contributions that they're going to have to be made aren't put off indefinitely, and they're essentially going to have to pay for the delay by implementing or by paying additional interest, as well as expecting higher contribution requirements in the future. So that's something that they need to be aware of. In addition, the Act essentially empowered the Department of Labor to extend certain deadlines for notices. And I know that the ARA has been reaching out to the Department of Labor to discuss a whole slew of required notifications, anything from QDIA notices to auto enrollment notices to SPDs, et cetera. They're requesting some additional relief and extension. So we're in a wait and see mode to see what the Department of Labor comes back with in regards to some relief for reporting and notices. And then finally, when we talk about timing and plan amendments, from a timing perspective, these are all available immediately. So it's possible that you may have seen, or your clients may have already seen, that quite a few of the record keepers are coming out with communications or some opt-out provisions like fidelity provided for the CRDs. And that's because the effective date for this is immediate. So all of these elements become immediately optionable for plan sponsors to add to their plans. Now, they will have to amend the plan document eventually, but they do have some leeway there, some lead time. The plan will eventually need to be amended, and that would be on or before the last day of the first plan year beginning on or after January 1st, 2022, or later if the Secretary of Treasury ends up extending the amendment period. So they do have some time to get the formal aspects in place, but they can start implementing this now, and they need to be talking to their record keepers to understand some of the procedural and administrative elements that might go into this. With that, that's the CARES Act. I want to go into some of the other topics on the next slide that talk about some items that your plan sponsors are probably going to need to be considering or talking about. So the first is the impact of furloughs. So I think what you're going to come across is a lot of your clients are going to be thinking about the difference between furloughing their employees, so not making it a temporary or making it a temporary removal, but not necessarily a full termination, or doing layoffs. And as we've seen already, many employers have already begun to furlough employees rather than terminating them. Under the IRS regulations, employees with plan loans who are placed on unpaid leave of absence, they can forego making loan payments during the leave absence. So a little bit like what we saw under the CARES Act. Now in this situation, if the plan is not going to take advantage of the CARES Act extension, and I apologize, I have a dog barking right next to me. They may choose to just follow furlough procedures under the Internal Revenue Code regulations. And if that's the case, they can allow the participants to forego making the loan repayments during the leave of absence without triggering taxation, as long as the furlough period doesn't exceed 1 year, and that the loan has to be repaid by the end of the original term. So that's a little different again than what we're seeing from the provisions under the CARES Act that allows some extension. So I think that that's an important consulting piece to bring up with your clients. Do they want to operate under the current rules or do they want to loosen them for their participants under the CARES Act? The next thing that you might be seeing, our clients are under tremendous financial burden right now. And some of them, you know, are by definition, just for the survival of their country, going to have to do some layoffs. And as a result, they might end up with a partial plan termination. And it's incredibly important for these companies to understand what the rules are regarding that. So first of all, a partial plan termination is going to be presumptively triggered if there is 20% or more reduction in force. So that's an IRS rebuttable presumption. It's essentially really a facts and circumstances test, but everybody used to wonder what was the bright line, and so the IRS put forth this 20%. Now understand that based on the facts and circumstances, it might be a partial plan termination if the percentage layoff is less, and it could end up not being a partial plan termination if the percentage of layoff is more than the presumptive threshold. But that would require some conversation about all the facts and circumstances with the IRS. If you're looking for what the potential outcome is, remember, if you have a partial plan termination, then you have to bring, your clients have to bring all of their affected participants to full vesting. So for plans that have 100% vesting already, this might not be a big issue, but for those that have an employer contribution that's not 100% vested immediately, that has a vesting schedule, this might have a real material impact. So that's something that you should at least be listening for with your clients, is if they're having any reductions in force, and that should trigger a conversation about partial plan terminations. Plan investments. So remind your clients that while there's a lot of relief being offered in the CARES Act and in a lot of different actions that the government is taking right now, there's no cessation of their fiduciary obligation. So anything that they were doing prior to this to meet their fiduciary responsibilities in regards to investments and fees, et cetera, that's going to be ongoing. They continue to need to meet those responsibilities. And I know that this is perhaps a difficult time for a lot of those companies to understand how to prioritize this, right? I mean, most of them, to a certain degree, might be facing inner challenges of how to continue operations or how to even survive. And so it's worthwhile for you as plan sponsor advisors to take that into consideration and to figure out how you can pivot with how you're delivering services to them to make it as easy as possible for them, but to keep them on the right path in regards to making investment decisions. The next element that is coincident with that is, okay, if you're following a prudent process and you're providing investment reviews and something comes up that necessitates a change, then what do you do? Particularly in these incredibly volatile markets, right? I mean, we're seeing swings of, 400 to 1,000 points in the Dow on a daily basis. This is not the normal swings of volatility. So you have to bring that into play when you're talking to your clients and decide, and they need to decide what they think is the most prudent course of action, because it's not only the actual change that you might be recommending that might be prudent, but the next question that comes into play is, well, what about the timing? Because the timing needs to be prudent as well. And the potential dangers here are, one, if the change is going to necessitate money being out of the market for any considerable period of time, even a day with these swings can be really detrimental to accounts. You have to weigh that against the benefits that the change would engender to the plan participants and make a cost-benefit analysis as to whether or not you need to make that change now or maybe put it off for later. Where this comes into play, I think in even greater fashion, is when you have some blackout periods that might be even more than a day. So conversions are a great example of that, when a plan is moving from one provider to another, and they might not be out of the market for that entire blackout period, but participants might not have the ability to make fund changes or fund election changes during that blackout period. In other words, they can't control where they're putting their money. And I've seen these blackout periods be, up to 3 weeks, 21 days. That's a long time during these volatile times for participants not to have control of their money. Now, that said, there's still fiduciary protection under 404C. So, understand that as long as they're crossing T's and dotting I's and they're meeting their 404C requirements, fiduciaries are probably protected, but that doesn't mean that they're not going to end up acquiring a lot of bad will with their employees if they go through that process through such a tremendously volatile market. And it doesn't necessarily stop potential lawsuits, which, while they might prevail on the merits based on 404C protection, doesn't negate the cost of having to go through that litigation. And that's both a monetary cost as well as a time cost. So they need to be aware that they really need to be making prudent decisions all the way along, and they're not allowed to suspend their fiduciary responsibilities. Another item that might come up, we see a lot of changes that employers are making at present in regards to how they're trying to compensate their employees. A lot of them are, doing really good things and trying to bend over backwards and keep compensation going to employees in different fashions that concurrently will also allow the company to continue to survive. Well, that creativity, while great for the participants' current health, might create some issues from a plan design and a following the terms of your plan document perspective. So please be reminding your clients that when they're doing anything creative with compensation, that they also need to concurrently take a look at what the terms of their plan document say in terms of compensation, and then adjust accordingly to these new types of compensation that they might be creating, or new fringe benefits that they're creating, and figure out how that interplays with the terms of the plan document. And then, a real big one is employer contribution. If there's any one area that we are receiving the most inquiries right now, it's about what to do if an employer needs to pull back and or cease their contributions altogether. And what that really boils down to is kind of the type of contributions that they're making. So first of all, if they're discretionary in nature, and that can be either a match or a profit sharing or a qualified non-elective piece, if it's discretionary in nature, they need to take a look at the terms of the plan document very closely to make sure that they can stop based purely on their discretion, but they should be able to do so. Now, that said, I think it behooves them to reach out to their participant base and let them know that they're making that change, but there's nothing that legally requires notification or timing for a discretionary contribution. Now, attendant with that, they have to be aware that at the end of the year, they might have to do some additional non-discrimination testing that they haven't done prior, because now they've essentially created two classifications of employees. The first being all those that received the contribution at the beginning of the year, and the second being all those that might have become eligible for it later and didn't get it, or that were hired later and never had an opportunity for it. So there's going to be some additional non-discrimination testing at the end of the year, but that's obviously not of immediate concern. So that's discretionary. The second is if their plan document has a stated contribution, so a stated match, a stated formula, or a stated profit sharing piece. For those plans, they can be amended to remove those, but that's the key. Unlike discretionary, where they can make that decision on the fly, as long as they've got some formal corporate action that effectuates that, like a board resolution. In the instance of a stated contribution, they have to formally amend the plan, and they have to provide a summary of material modifications for that, and they can't reduce or stop the contributions prior to the effective date of that amendment. So they're going to have to get on the horn with their record keepers to make sure that they're crossing all their T's and dotting all their I's. And then similarly to the discretionary, at the end of the year, you're going to have that same additional non-discriminatory classification testing to determine if the plan is indeed non-discriminatory in regards to the two groups of populations that have now been created. The final aspect under employer contributions talks to safe harbor design. And this is incredibly important because not all plans are safe harbor, but for those that are safe harbor, there are some very specific rules. So plans may amend their plan mid-year to reduce or to eliminate a safe harbor contribution. However, they have to meet one of two aspects. Either one, the employer has to be operating at an economic loss. And there's some conflict in the language regarding that part of the rule. So first of all, it talks about for the plan year, which would lead us to believe that you have to be operating at an economic loss for the entire plan year. Now that said, that's not consistent with the reason for this, which is a mid-year change, which means that you can't possibly project and know if you're going to be operating at a loss for the whole year. And similarly, when we take a look at the tense of the verb being used, it says operating. It doesn't say operated. So it really leads us to the belief that there's a strong likelihood, and when I say strong, I think very strong, that you are allowed to look at the operating losses at the current time for the employer to lean on that aspect. Now, conversely, you don't need to have the operating loss if you had a safe harbor notice that went out at the beginning of prior to the beginning of the year that contained language that essentially stated that the plan sponsor may amend the plan during the plan year to reduce or eliminate the safe harbor contribution. Now, don't automatically assume that the safe harbor notice had that language. Go out to your clients, ask to see their safe harbor notice and look for that explicit language, because absent that language, they're going to have to fall back on that operating loss aspect. Otherwise, if they suspend or they reduce and they go non-safe harbor, and the IRS comes in on a later date and sees that A, there's no operating loss, and B, the notice didn't say that, they're going to retroactively apply the safe harbor requirements, and the employer is going to have to come out of pocket not only for the contributions that they didn't make, but also for missed earnings from the date that they stopped them. Now, all that said, if the plan is going to be capable of reducing or eliminating the safe harbor contribution based on one of those two elements, the actual reduction cannot occur earlier than 30 days after all eligible employees are provided notice and the plan is actually amended. So you can't apply this and then amend afterwards. The plan needs to be amended prior, and you have to give at least 30 days notice to participants so that they know that the suspension or the reduction is coming. Finally, it's really important to understand that participants on a general basis tend not to be quite as critical of their account balances in their retirement plans during bull markets. When they see the markets going up, they're happy. They might just click on the front page, see where their account balance is at on any given day, and that's it. When we've come into bear markets and we experience what we're experiencing today with all this volatility, this is when participants tend to take out the microscope and start examining their plan in a lot more detail. People experience loss at twice the magnitude that they experience gain. This has their attention. If this has their attention, it also means that any poking around that's being done by class action plaintiffs' attorneys is also going to have their attention. There's going to be a lot more talk about what's quote unquote going astray with their plan. And where is the greatest volume of litigation over the last 10 years? It's in fees, excessive fees. So what did I say earlier about fiduciary responsibilities? They're not told during this experience, which means that not only are your plan sponsor clients going to be held to task for the investments in their plan, but also for fees, because remember, it is a fiduciary responsibility to defray reasonable fees of the plan. And so they have to be aware that their fees are reasonable, and they have to be able to show some way that they have benchmarked the fees. And part of that is in conducting periodic live bid solutions for their clients. But in the interim years, they really need to find a way to be benchmarking their plan against other fees that are of like and similar design for their plan that has reliable data. And so with that, I think we're going to turn it over to David to kind of walk through what's available on the market. So thank you. And